This is English Shorthand Dictation number 321, and the dictation speed is 100 words per minute. Ready? Start. The question arose for consideration in the case of Ahmedabad Private Primary Teachers Association as to whether teacher could be regarded as an employee under section 2E of the act, and if so, whether he is entitled to claim gratuity amount from his employer in accordance with the provisions of the act. The two-judge bench examined this question in detail. Justice Dharmadhikari, speaking for the bench, held that a teacher is not an employee within the meaning of the expression employee as defined under Section 2E of the Act, and hence he is not entitled to claim any gratuity amount from his employer under the Act. In other words, it was held that since a teacher is not an employee under Section 2E of the Act, he has no right to invoke the provisions of the Act for claiming gratuity under the Act from his employer. On behalf of the municipal corporation, it is contended that the only beneficial effect of the notification issued under Section 1(3)(c) of the Act of 1972 is that such non-teaching staff of educational institutions as answer the description of any of the employments contained in the definition clause 2E would be covered by the provisions of the Act. The teaching staff being not covered by the definition of employee can get no advantage merely because by notification educational institutions as establishments are covered by the provisions of the Act. Having thus compared the various definition clauses of the word employee in different enactments with due regard to the different aims and objects of the various labor legislations, the bench held the view that even on plain construction of the words and expression used in the definition clause 2E of the Act, teachers who are mainly employed for imparting education are not intended to be covered for extending gratuity benefits under the Act. Teachers do not answer description of being employees who are skilled, semi-skilled, or unskilled. These three words used in association with each other intend to convey that a person who is unskilled is one who is not skilled, and a person who is semi skilled may be one who falls between the two categories, meaning he is neither fully skilled nor unskilled. The Black's Law Dictionary defines these three words. Semi skilled work is work that may require some alertness and close attention, such as inspecting items or machinery for irregularities or guarding property or people against loss or injury. Skilled work is work requiring the worker to use judgment, deal with the public, analyze facts and figures, or work with abstract ideas at a high level of complexity. Unskilled work is work requiring little or no judgment and involving simple tasks that can be learned quickly on the job. In construing the above mentioned three words, which are used in association with each other, the rule of construction may be applied. As per the rule of construction, the meaning of an unclear or ambiguous word in a statute or contract should be determined by considering the words with which it is associated in the context. It is a legitimate rule of construction to construe words in an act of parliament with reference to words found in immediate connection with them. The actual order of these three words in juxtaposition indicates that meaning of one takes color from the other. The word unskilled is opposite of the word skilled, and the word semi-skilled seems to describe a person who falls between the two categories, which means he is not fully skilled and also is not completely unskilled but has some amount of skill for the work for which he is employed. The word unskilled cannot therefore be understood dissociated from the word skilled and semi skilled to read and construe it to include in it all categories of employees, irrespective of the nature of employment. If the legislature intended to cover all categories of employees for extending benefit of gratuity under the act, specific mention of categories of employment in the definition clause 8 was not necessary at all. Any construction of definition clause which renders it superfluous has to be avoided. The contention that teachers should be treated as included in the expression unskilled or skilled cannot therefore be accepted. The teachers might have been imparted training for teaching, or there may be cases where teachers who are employed in primary schools are untrained. A trained teacher is not described in the industrial field or service jurisprudence as a skilled employee. Such adjective generally is used for an employee doing manual or technical work. Similarly, the words semi-skilled and unskilled are not understood in educational establishments as describing nature of job of untrained teachers. We do not attach much importance to the arguments advanced on the question as to whether skilled, semi skilled, and unskilled qualify the words manual, supervisory, technical, or clerical, or the above words qualify the word work, even if all the words are read alternatively or in any other manner. Trained or untrained teachers do not plainly answer any of the descriptions of the nature of various employments given in the definition clause. Trained or untrained teachers are not skilled, semi skilled, unskilled, manual, supervisory, technical, or clerical employees. They are also not employed in managerial or administrative capacity. Occasionally, even if they do some administrative work as part of their duty with teaching, since their main job is imparting education, they cannot be held employed in managerial or administrative capacity. The teachers are clearly not intended to be covered by the definition of employee. The legislature was alive to various kinds of definitions of the word employee contained in various previous labor enactments when the act was passed in 1972. If it intended to cover in the definition of employee all kinds of employees, it could have as well used such wide language as is contained in Section 2F of the Employees Provident Funds Act 1952, which defines employee to mean any person who is employed for wages in any kind of work, manual or otherwise, in or in connection with the work of an establishment. Non-use of such wide language in the definition of employee in Section 2E of the Act of 1972 reinforces our conclusion that teachers are clearly not covered in the definition.